Good morning, everyone. Good morning. My name is David Giannotti. I'm with the State Ethics Commission, and we're here today for a Conflict of Interest Law seminar. My job at the Ethics Commission is to talk about how the Conflict of Interest Law applies to us as public employees, and we're going to go through the various sections of the law. You have a handout of my PowerPoint slide up here. As we go through the presentation, just a couple of ground rules. I'm not an attorney, so I can't give out legal advice. If you have a question about how the Conflict of Interest Law might apply to your specific situation, I would urge you to contact the Ethics Commission and talk to one of the attorneys in our legal division. It's their job to provide public employees with specific advice on how to comply with the law. We do that in a confidential setting. Also, as we go through the various sections of the law, if you have any questions, please keep them hypothetical. In other words, please don't tell me that you violated the conflict law, not that you came here with any questions, but in the event that you do, just observe that provision and that'll be fine. So I'm going to go through the PowerPoint slides. I'm going to talk about the law in a very high-level sense. This should take about a 90-minute for the presentation. So the premise under Massachusetts law as public employees is we have to keep separate our public responsibilities and our outside private interests, because as state employees here at the lottery, we serve the public interest, however that is defined. It is the mission of the lottery. It is the mission of government in general. And the Conflict of Interest Law seeks to maintain confidence in government, integrity in the work we do as public employees. And what the Conflict of Interest Law does is it restricts those situations where public employees in performing their duties might be influenced or have outside interests that might be affected by what they do as public employees. Now, conflicts of interest, they basically break down two ways: financial interest conflicts and everything else. As to financial interest conflicts, the law restricts whether you as a lottery employee can participate as a lottery employee in any matter that affects your financial interest or certain other financial interests that we'll get into. We use the terms abstain and recuse to reflect those situations where public employees, when presented with a financial interest conflict, step back from handling the matter, because that's what the law requires unless your appointing authority, whoever is responsible for appointment to your position here at the lottery, gives you written permission. And we'll talk about the mechanics of how that might work. So financial interest conflicts, and then there are non-financial interest conflicts that'll fall under the Code of Conduct section, which we'll get into. And as to non-financial interest conflicts, the law does not prohibit us from doing our jobs when presented with that kind of a conflict, but it requires that we create transparency. And we create transparency by filing a written disclosure of the conflict of interest to dispel an appearance problem that is otherwise created. And so that's basically it under the conflict law: financial interest conflicts and everything else. So in any event, that's Conflict Law 101 at its highest level. The premise under Massachusetts law is that public employees have to keep separate their public responsibilities and their outside or private personal interest. Now, one other point I wanted to make about that is, okay, public responsibilities, that's our job here at the lottery. What are outside or private interests that might rise to the level of a conflict of interest? And the short answer to that question is any component of your private life. Who you are, where you live, who your family members are, who your friends are. For example, what church you might belong to, what nonprofits you might affiliate with off the public job. Any component of your private life is potentially an outside interest for conflict of interest law purposes. Now, it doesn't drill down to everyone you've ever met in life. The law would distinguish an outside interest as someone who is a friend, someone you associate with off the job, you attend each other's social functions, family functions. If a matter at the lottery affects a friend, that would be a conflict of interest. It would require disclosure before you perform your duties as an employee. But an acquaintance does not rise to the level of an outside interest for conflict law purposes, like people you see in the coffee shop or you just know in passing, but you're not otherwise friends. The law doesn't restrict your ability to handle matters that might involve an acquaintance. The Commission's website off the portal, the state's portal, we have useful information up there. Now, it's not a very deep site because the Ethics Commission is required to operate in secret. When the Ethics Commission was formed in 1979, strict confidentiality requirements were imposed on the Commission, statutorily imposed. So as a practical matter at the Commission, as we perform our work, we can't confirm or deny to anyone outside the agency whether we've received a complaint, whether we're conducting an investigation, whether any public employee has sought or received advice from the Commission on how to comply with the law, all required to be kept confidential. So our site doesn't have all the work that we've ever done, but it does have some materials there that explain the conflict law. We have various educational materials, advisories that I'm going to talk about in a certain sense, which explain the law in a general sense. We have legal opinions. Most of our opinions are required to be kept confidential, but if it's the Ethics Commission, as opposed to one of our staff attorneys that approves an opinion, they do that only in limited instances where our legal division is uncertain about how to give advice. So any opinion approved by the full commission is precedent. And so those are posted up on our website. We're allowed to do that, except we redact the requester's information. Enforcement decisions, most of what we do we can't talk about, but if the commission approves a decision in an enforcement case where they find that somebody has violated the law in a significant way and they need to pay a civil penalty in the interest of justice, those decisions by the commission are public and they are posted up on our website. Disclosure forms. I'm going to talk about disclosure as a way to comply with the conflict of interest law. And whenever I say disclosure or talk about disclosure, it has a distinct meaning. In order to comply with the conflict of interest law, if a public employee has to file a disclosure, it is in writing. It has to be a written statement. It has to be filed in a specific way. For our purposes, we would file a disclosure with our appointing authority, whoever is responsible for appointment to our position. In most cases, it would be the executive director or it would be the treasurer, whomever. So they have to be filed in a specific way and they have to be preserved as public records. So in order to comply with the conflict law, written statement containing all the relevant facts, filed with our appointing authority, preserved as a public record, and conflicts of interest, they're going to happen. Maybe not to you, but certainly to other people that you work with, and they occur every day in public life. They're not to be feared. What they are is to be managed. And managing conflicts of interest is all about getting out in front, anticipating the situation, finding out whether the law applies, what are the compliance rules, and then complying with the conflict law. In the context of having to file a disclosure has to be filed in advance of any conduct that implicates the conflict of interest law. It does not do any good to violate the conflict law and then file a disclosure afterwards. In the same way about obtaining advice, don't guess, call us. That's what we're there for. Most of the work we do at the Ethics Commission involves education. Even in an enforcement context, we receive upwards of 1,000 complaints a year, but most of those complaints are resolved confidentially with confidential education letters. The Commission will only take public enforcement action in a very small number of cases, maybe 1 to 2 dozen a year. Only those cases involving serious violations of the law, willful misconduct, self-dealing, unlawful enrichment, will the Commission take public action. Most of the cases, however, are resolved confidentially, where we explain to the person how the law was implicated and what to do to comply with the law in the future. So if you need advice, you contact our office, you ask to speak to the attorney of the day. We have staff attorneys in our legal division on rotation and they give advice. And we get thousands of calls every year, so don't be afraid to call us. In most cases, it's a quick 5 or 10 minute phone conversation. We prefer email because then that serves as a record. What are the facts presented to us and what was the advice we provided? Because we record all contacts that come into the agency out of necessity, because there have been instances where conflicts of interest have been reported about locally, and somebody will report that, well, they contacted the Ethics Commission, and we'll verify with our records and find out that, yeah, while they called, we returned the call, didn't get a call, and we never spoke to the person. Or we want to find out what specific advice we provided, because there have been situations where somebody will say, well, I called the commission and got advice, and then, well, it would have been nice if you followed the advice. So we need to record all the calls that come in so that we can verify what advice we gave in a particular situation. But you can also fill out an online form off of our website. It will attach to an email as a PDF, a fillable form, and you can submit a request for advice that way. We do not give out third-party advice. What that means is, and it's because of the confidentiality restrictions, we can talk to you about your situation, but if a coworker, subordinate, or what have you would ask you to obtain advice on their behalf, we can't talk to you about what somebody else needs to do to comply with the law. They need to contact us directly. In certain limited instances, if we have the employees express permission for you to obtain advice on their behalf, we will do that. But for the most part, we'll deal with agency counsel that way, people that understand the law other than a rudimentary understanding. And also, past conduct advice. The way we get out in front and manage conflicts is to make sure we know when the red flag should go up, and then we take the time to find out what the compliance rules are. And so it doesn't do a person any good to violate the law and then call our legal division afterwards to find out whether they violated the law, because it's then out of their purview. Our legal division, when handling those kinds of calls, will defer any advice and suggest that, you know what, we can't talk to you, but our enforcement division is available. They'll be very happy to talk to you about the situation, because it becomes the enforcement division's responsibility once it's a past conduct situation. Okay, that's sort of the housekeeping. Let's talk about the various sections of the conflict law. There are several sections governing gifts. The question being, can I as a public employee accept a gift from someone? Well, the answer to that question, as well as all questions under the conflict law, is it depends. It depends on the circumstances. So let's talk about what some circumstances might be under the conflict law. Well, first of all, the conflict of interest law prohibits public employees from soliciting or receiving bribes. And the law also applies to folks that might deal with public employees. They are also prohibited from offering or giving bribes to public employees. Now, what is a bribe? Well, a bribe is a corrupt act. The corrupt element of a bribe is something called a quid pro quo. In a bribery situation, someone dealing with a public employee who might need something that the public employee can provide, but they might not otherwise qualify for, might attempt to leverage the situation. In a bribe situation, whatever rules guide the public employee in how they do their job, because we're required to treat all similar matters similarly, in other words, to treat everyone the same. If a public employee fails to follow the rules because of some item of value that was provided to them, any item of value that get the public employee to do something, to not do something, or if there's some collusion to commit a fraud on government, a corrupt act, violates the bribery section. The Ethics Commission is a law enforcement agency. We enforce the conflict of interest law civilly, not criminally. The Attorney General can enforce the law criminally, because under this bribery section and several other substantive sections of the law, there are criminal penalties for violations. On the civil side, the potential civil penalty is $25,000. On the criminal side, it's $100,000. And a potential jail term of 10 years for violating. And as I said, both the public employee and any person that offers or gives a bribe can violate this section of the law. The middle bullet point deals with gifts and gratuities, what we refer to as illegal gifts and gratuities. The conflict of interest law prohibits anyone from offering or giving to a public employee, or for a public employee from soliciting or receiving any item worth $50 or more. The statute says any item of substantial value, and that term is defined by the Commission to mean anything worth $50 or more that is given to the public employee for or because of some official act performed or to be performed. What that does is it creates a nexus. It's not sufficient that the gift be given, but it's in connection with some official business between the giver and the public employee. If it's worth $50 or more, it is prohibited under the conflict of interest law. And again, both parties, the public employee and the giver, can violate the conflict law. For violations of this section, it's a potential civil penalty of up to $10,000. The bottom bullet point was added to the law in 2009, and it takes out the nexus. The bottom bullet point says that the public employees may not solicit or receive anything worth substantial value that is given for or because of official position. In other words, you don't even need to have any official dealings with somebody. If they come up to you and give you 2 tickets to the Red Sox game and the value of both tickets is $50 or more, it is prohibited. The person giving the item of value doesn't violate the conflict law unless certain egregious circumstances are present, but the public employee would violate the conflict law. So in a nutshell, the gift restriction rules prohibit public employees from soliciting or receiving bribes, gifts that are worth $50 or more and given because of official position, and gifts worth $50 or more that are given for or because of some official act performed or to be performed. Now, there is also a question about, well, what about gifts worth less than $50? Well, the conflict law doesn't restrict public employees from accepting items of value worth less than $50, less than substantial value, except if the receipt of an item worth less than $50 creates an appearance problem, a disclosure is required to comply with the conflict of interest law. Now, one caveat there is the commission can aggregate, which means is if somebody pays for a lunch or a dinner and it's worth less than $50, the conflict law doesn't prohibit it. Agency policy might restrict it, but the conflict law doesn't prohibit it. But if there are multiple occurrences from the same source within a 365-day period, the commission can aggregate those individual amounts, and on the aggregation, once it reaches $50 or more, which you can imagine won't take too long, it then becomes actionable under the conflict of interest law. But aside from that, say that there is no aggregation. We can accept items worth less than $50, but we may have to disclose to the boss that we received that item. Let me give you an example to illustrate the point. So, say I'm a public school teacher in a city or town. That would make me a municipal employee for conflict law purposes. I'm required to observe all the same provisions of the law that state employees have to. And the parents of one of my students have provided me with a $40 gift certificate to my favorite restaurant. Now, I can accept that gift certificate because it's not worth $50 or more, and presumably it's not a bribe. But does it create an appearance problem such that I would have to file a written disclosure to comply with the conflict law with my appointing authority? In the case of a school teacher, would be the principal. The answer is it depends on the circumstances. So let me give you a couple of scenarios to illustrate further. Scenario 1 doesn't create an appearance problem. I get the gift certificate at the end of the school year. Now, if I get it at the end of the school year, presumably the student is moving on to the next grade level. As a teacher, in all of my official responsibilities as a teacher and all of the people I interact with as a teacher, I'm no longer going to have any official dealings with the student or the parents who provided the gift certificate, so it doesn't create an appearance problem. What is the appearance problem? Well, that once I get that gift certificate, I might then be predisposed to show preferential treatment to the student or the parents because of that gift. Now, where the student is moving on to the next grade level, I don't have that opportunity. That situation does not create an appearance problem. I can accept the gift certificate. I don't have to disclose that I received that gift certificate to the principal. Scenario 2 does create an appearance problem. I get the gift certificate in the middle of the school year. And, oh, by the way, the parents have also asked me to write a letter of recommendation because they want to get their child into an AP class. And, oh, by the way, the parents of several of my other students have made similar requests. I can't write that many as a teacher. I don't have the time for that. In that instance where I get that gift certificate and I'm going to continue to have dealings with the student and the parents, it does create an appearance problem. What is the appearance problem? Well, that I might show the student or the parents preferential treatment because I got the gift certificate. How? Well, that letter of request that they've requested might go to the top of the pile at the expense of everyone else. The student might get more of my time to help them learn the material at the expense of my other students that need as much of my time as I can provide. And so where that does create an appearance problem, while I can accept the gift certificate, I do have to file a written disclosure with the principal that I received the gift certificate. And under the section of the law governing non-financial interest conflicts, which we're talking about, or the Code of Conduct section, agencies are free to adopt their own standards. So while the conflict law says I can accept the gift certificate, if agency policy says no, I cannot, well, that's what would control. Like, for example, Massport is a state agency. They have a zero tolerance policy, a personnel policy, that restricts their employees from receiving any item of value from people that they deal with as public employees. And that's what would control in their situation, despite the conflict law's restriction on items worth less than $50. So here are examples. Any item of value in any way, shape, or form conveyed from one person to another can implicate the gift restriction rules under the conflict of interest law. So we have meals, event tickets, travel or expense reimbursements, gift certificates, floral arrangements, fruit baskets, lottery tickets. If somebody provides me with a $50 scratch ticket, what's the value? $50 or more, it's prohibited. What if I accept it and scratch it and it comes out no winnings? Well, it still was something worth $50 provided to me as a public employee. It would be restricted under the conflict of interest law. Event tickets. The Commission has put out advisories from time to time on when situations have developed and the Commission felt compelled to advise public employees on the conflict law requirements. And in 2004, the Commission put out an advisory concerning event tickets. Should public employees accept tickets to events? Now, what happened in 2004 that might prompt that kind of an advisory? Well, think about back then what happened with the Patriots and the Red Sox. And so in connection with all of that, we were getting calls from public employees concerning whether public employees could accept tickets. So the Commission puts out an advisory reminding public employees about the gift restriction rules. Now, the bottom bullet point on the previous slide wasn't in play at the time because that wasn't put into the law until 2009. But back in 2004, the gift and gratuity section prohibited public employees from accepting items worth substantial value given for or because of official acts. And so the Commission said in the advisory, public employees, it's not a good idea to accept event tickets from people that you deal with as a public employee. Public employees were asking, well, what if I pay for the tickets? And the Commission announced, well, wait a minute, even if you pay for the tickets, if you're being given access to an event, a coveted event like a World Series game, Super Bowl, playoff tickets to the major sports teams, you're being given special access to an event that an average member of the public doesn't enjoy. And that special access alone is an item of substantial value. And that would be prohibited under the conflict of interest law. But if you pay face value for a ticket to a coveted event, what's the actual value of those tickets? Is it the face value? If you get a ticket to the World Series and the ticket has a face value of $45, what's the actual value of that ticket? It's going to be more than $45 by a long shot. And the Commission has said we will attach actual value to event tickets where it's a coveted event. So if the actual value, and you can go on StubHub or Ace or Craigslist or what have you, is more than face by $50 or more, it's also problematic under the conflict law. And then in situations where public employees said, well, what if I pay the actual value for the tickets? Well, you still don't get around the special access situation, but say for the sake of argument you do. Then you're just picking your poison. Because while you might eliminate conflict of interest issues by paying face value for an event ticket, you could be violating the scalping laws because the person providing you that ticket is not an authorized ticket broker. And so generally the Commission and the advisory said public employees don't take event tickets. These situations become problematic on several different levels. Does anyone here fill out a financial disclosure statement with the Ethics Commission, what we call SFIs? Okay, there's also a gift restriction that's contained in the financial disclosure law. Now, we're here today to talk about the conflict of interest law, but the Ethics Commission also administers and enforces the provisions of the state's financial disclosure law. And there are about 4,500 state and county officials and employees who have to annually file a financial disclosure statement with the Ethics Commission. And for those people, there is a gift restriction that says they cannot accept gifts of any value from lobbyists. And the lobbyist is similarly restricted under the financial disclosure law. So the Commission over the last several years promulgated regulations where it looked at everyday situations involving public employees where the public employee might receive items worth $50 or more given for or because of official position. And it looked at situations and said, if we can remove the conflict of interest law mischief, there are situations where it might promote the public's business and the public interest to allow public employees to accept items worth $50 or more given because of their official position. And so it promulgated regulations that said in these real-life, everyday situations facing public employees, as long as there's no conflict of interest mischief, we will create a regulation creating an exemption from the gift restriction rules. And so we've got some categories here where exemptions from the gift restriction rules may be available to public employees. Now, I'm not going to speak about all of them. I'll just touch on the most common one. That being the top one, travel and expense reimbursements, where the purpose of the travel serves a public purpose. Public employees attend conferences, just like employees in the private sector. And there's real value. And we recognize the value of public employees attending conferences because that's where we learn how to do our jobs better. We step outside the normal formal constraints on the work we do as public employees, and we learn best practices, new products, new rules, new regulations. We network with the people that we have to network on the job, and we build relationships. We learn how to do our jobs better. Now, what happens in situations where you have the opportunity to attend a conference or some event that serves a public purpose, but the agency cannot pay your expenses? Because the way it works in government is you incur an expense, your agency reimburses that expense. But especially when the economy downturned, that became problematic. So the Commission looked at those situations and said there's real value to public employees being able to attend these events. So as long as public employees disclose their ability to attend those events and their appointing authority endorses their attending that event by, on that disclosure, making a determination that the employee's attendance at the event serves a legitimate public purpose, it takes out any conflict of interest mischief. Why? Because it creates transparency. Number one, creates transparency so that people that might think, well, this is a junket or some wining and dining opportunity. No, it's an event that serves a public purpose. There is a disclosure that says that, and the boss endorses the employee attending the event. It takes out the conflict of interest law mischief. The disclosure has to be preserved as a public record. So that's sort of how the regulations work. Situations that otherwise implicate the gift restriction rules, if certain conditions apply, things will be allowed. Incidental hospitality that serves a purpose. If you're invited to an event hosted by some private entity and they're serving food and beverage, people might get some notion that this is a wining and dining experience. But as to events that serve a public purpose, weekday educational or informational events where a meal is being served, or it's coffee and pastry even, the regulation allows public employees to accept those items provided that they file a disclosure. Now, if somebody were to provide a meal to a public employee and the meal cost $50 or more, it would be definitely problematic. But even in instances where the coffee and pastry is not going to cost $50 or more, people might get the wrong idea that somebody's trying to leverage relationships with public employees. And so the disclosure creates the transparency that the conflict law seeks so that people who might otherwise get the idea that it's a wining and dining experience, it dispels that notion. And so here are some of the other categories. I just want to touch on unsolicited perishable items because that's a big one facing agencies. What if you're dealing with a vendor and they send you a bouquet of flowers or an edible fruit basket? Those items all cost more than $50 at this point in time, and so it implicates the gift restriction rules. But the commission created a regulation that said, hey, as to perishable items, because they're perishable, it's impractical to refuse or return those. So as long as those items are unsolicited, public employees do not have to refuse or return those, but you do have to eliminate the element of a violation, which would be the $50 rule in this case. We can't accept anything worth $50 or more given because of our official position. So how do you eliminate that in the context of receiving a perishable item? You share the item. The whole notion being that no one public employee receives anything worth $50 or more. So you share it. So if you get a bouquet of flowers from a vendor, you don't keep it in your back office. You put it out at reception, out at the front counter for everyone to enjoy. If you get the edible fruit basket and you want to take out those chocolate-covered strawberries to leave the apple slices and pineapple for everyone else, you just make sure that when you do that, the amount of what you take does not exceed $49.99. You share the item so that no one public employee receives anything worth $50 or more. So that's sort of how the regulations work. Just to let you know that while we have these gift restriction rules in place, there are exemptions that may be available. Okay, so that takes us from the gift restriction rules. Now let's talk about financial interest conflicts, a section we call the nepotism section. Nepotism or self-dealing. Public employees, rather than serving the public interest, are involved in taking care of themselves or their friends or their family. So the conflict of interest law, as to financial interest conflicts, says, state employee, you may not participate as a state employee in particular matters if certain financial interests are affected. Number one is yours. Number two, your immediate family members. Number three, any business organization in which you are privately employed or in which you own or operate, that you serve as an officer, director, partner, or trustee. Also on the list, a business partner. And then finally on the list, anyone or any organization with whom you're negotiating for employment. In other words, public employees cannot use their public positions to leverage career opportunities. If you're dealing with folks as a public employee and you're then negotiating for employment, you have to stop any further dealings. By necessity, you will have to disclose to the boss and to the Ethics Commission that you can't deal with this particular entity because you're involved in negotiations with them, employment negotiations. Because the law imposes an affirmative duty. It looks like financial interest conflicts. If it's a financial interest conflict on a matter that, yeah, you might deal with it, but somebody else in the office can deal with it, you just step back, you abstain, you recuse from further participation. But there may be certain issues that occur in connection with matters that you, by virtue of your position with the agency, is required to handle. And so the conflict law, this nepotism section, says that as to financial interest conflicts that occur in connection with matters that the employee is legally required to handle, not only do they have to step back, but they have an affirmative duty under the law to file a disclosure of that circumstance. You have to disclose the financial interest conflict two places. One, with the agency, with the executive director or the treasurer, whomever your appointing authority is. And number two, with the State Ethics Commission. If you don't file it in two places, you're not complying with the law. And then the appointing authority, upon receiving that disclosure, also has an affirmative duty to resolve the conflict. What do? And the appointing authority can do one of three things. Take responsibility for the matter from you and handle it themselves, or assign someone else to handle it, or, as to certain financial interest conflicts that are not significant, they can waive the statute. For example, say you're a department head and you have an immediate family member who works in your department. Now, you didn't hire the family member, that would violate the nepotism section. You don't supervise the family member, that would violate the nepotism section. But one of the things you have to do as a department head is certify the payroll for your department to comply with state finance law. Now, what happens if you sign off certifying payroll for your department and you have an immediate family member working in the department? That's participating in a matter that affects the financial interests of an immediate family member. So it violates the conflict law, but it's no big deal. All you're doing is putting your name on the line. So in that instance, where you have this financial interest conflict in connection with a matter that you're legally required to handle, you file the disclosure with the appointing authority and the commission. The appointing authority then decides what to do. Do they want to take responsibility for certifying payroll? Do they want to assign someone else to certify the payroll? Or do they want to make a determination that the integrity of your services by certifying the payroll, your financial interest conflict is not so significant so as it would affect the integrity of your services? If they make that determination, it waives the statute. If the boss says it's okay, it's okay. You create the transparency with the disclosure. They create the endorsement by making that determination on the disclosure. It's preserved as a public record. There's no violation of the conflict law. Okay, here's a chart for immediate family, and it's on a chart because the term immediate family is defined in the conflict law in connection with the nepotism section. You may not participate in matters affecting your financial interests or the financial interests of your spouse or of your parents or of your spouse's parents or of your siblings or of your spouse's siblings or of your children. Those are nepotism situations. So this then begs the question, well, I have more family members than what's on the chart. What does the conflict law say about my ability to perform my duties if it affects the financial interest of a family member who's not on the chart, what we'll call non-immediate family members? First of all, who are they? Cousins, aunts and uncles, nieces and nephews, grandparents, ex-spouses, domestic partners. If they're not on the chart, they're not immediate family, then if a financial interest affects them, it's not a nepotism situation. But by default, if it's not a nepotism situation, it then becomes a non-financial interest conflict, even though there's a financial interest component, but it falls under what we call the Code of Conduct section. That's a section that says, before we handle the matter, we have to file a disclosure with the boss. So we can participate in matters affecting the financial interests of non-immediate family members, provided that we file the disclosure with the boss. And under this Code of Conduct section, agencies are free to adopt their own standards, even if they're more stringent than the conflict law. So I can envision in that scenario that if you were to file a disclosure with the boss that some matter is going to affect a non-immediate family member, the boss might say, thank you for the disclosure, but no, you're not. I don't want you handling matters affecting the financial interests of anybody you know, whether they're immediate family, not immediate family, friend, what have you. And that's good public policy. The conflict law has its standard, but then the agency can adopt what it thinks is in the best interest of the agency. And so now we move from the nepotism section to the Code of Conduct section. And the first bullet point, that top bullet point, lays out the foundation for disclosure, the need for disclosure. This section says that state employee or county employee or municipal employee, you may not act in a manner in which a reasonable person, knowing all of the circumstances, could conclude that you would act with bias. In other words, that you could be improperly influenced in how you perform your duties. So it lays it out this way. You're the public employee, you're poised to do your job, and some component of your private life is going to be affected by what you do, but it's not a financial interest conflict. Those circumstances create appearance problems. Even though you're going to continue to serve the public interest and do your job the way you're supposed to, the mere fact that those circumstances are present creates the appearance problem, because when you are looking at a conflict of interest, it's not an internal analysis. It's not about whether you think you could be improperly influenced. All of the optics are outside in. What will a reasonable person looking at the circumstances conclude? And if the answer to that question is that I could be improperly influenced because this matter I'm handling will affect some component of my private life, that creates the appearance problem. Is there a chance that I might show someone preferential treatment? So before I handle the matter, even though I'm going to continue to serve the public interest, I have to have that disclosure filed with my appointing authority. A general principle under the conflict law is, as public employees, we cannot perform our duties with any hidden or undisclosed conflicts of interest. Financial interest conflicts, we have to stay away from those matters unless the boss says it's okay. Non-financial interest conflicts, we have to put the cards on the table first. We have to file a disclosure of those circumstances before we perform our duties to create the transparency, so that people who might think that we would be biased or could be biased, That disclosure dispels that so that it's not a reasonable conclusion. The second bullet point then says public employees may not use their public positions to secure unwarranted privileges for themselves or others that are not available to similarly situated individuals. And so what that means is, to the extent the way we do our job and the authority that we have as public employees, we have the ability to convey benefits to people who we deal with, we have to follow the rules in all instances. We cannot improperly use our position to secure benefits for those that we're connected to privately. Now, let me give you an example to illustrate that point. So say I work for a state agency and I have one job. I issue a permit. Doesn't matter what it's for, but people want the permit. And anybody that wants a permit has to come to me, and they have to do two things: fill out a permit application and pay a permit fee. Now, the term substantial value appears in this section of the law. That means anything worth $50 or more. So for the sake of my example, the permit fee is $100. And anybody that wants a permit has to follow those two steps. And then one day, my Uncle Harry comes into the office and he wants a permit. And I tell him, Uncle Harry, today's your lucky day. Today you get the friends and family discount. Fill out the permit application, but you won't have to pay the fee, and I'll give you the permit. Now, in that instance, I've used my official position to secure an unwarranted benefit for someone I'm connected to privately. Why is it an unwarranted benefit? Because I'm not authorized to give out a friends and family discount. Everything we do as public employees to serve the public interest follows a rule or a procedure or a policy or a statute or a regulation. And part of the reason is so that everybody gets treated the same. We have to treat all similar matters similarly. We're not allowed to make up the rules as we go along. So under the conflict law, if a public employee deviates from the rules that normally guide what they do, and as a result of that deviation, someone that they're connected to privately, like my Uncle Harry, benefits by $50 or more, it's an unwarranted privilege on its face and it violates the statute. Also, this whole notion of using our positions to secure unwarranted benefits falls under the category of improper use of public position. An improper use of public position could also result from a use of public resources, state resources, for any non-state purpose. We are allowed to use the resources that come with our job for state purposes only. Any abusive private use of a public resource, quantified as something worth $50 or more, violates the conflict of interest law. It is an improper use of one's public position. And we'll get into more of that. The following slides really will talk in a little bit more detail on an improper use of one's public position. The bottom bullet point, disclosing confidential information. The conflict of interest law says, public employee, if you normally receive or review confidential information in connection with performing your duties, you may not disseminate that information to anyone who's not authorized to receive it. Now, inadvertent disclosures of confidential information, it happens. And the Ethics Commission isn't so concerned about that. But if a public employee disseminates confidential information to anyone not authorized to receive or review it, and they do so to further a personal purpose, that's what would get our attention. That violates the conflict of interest law in a significant way. And we had a case involving someone in one of our district courts who didn't have access to CORI information, but went to somebody in the courts who did have access to CORI information. And this person asked the other person to run a CORI check on a person. Now, this person A had a relative who was running for an election locally. And she asked the other person in the court to run a CORI check on her relative's opponent in the upcoming election. Now, the person running the CORI check was authorized to do so, didn't have the context as to the nature of the request, but ran the check, came up with a record, provided it to his colleague, who then released that information to her relative, who then released that information to the media, and guess who won the election? Well, the commission learned of the conduct, and the commission, in its decision and finding, said, court employee, respectfully, even though you were not cleared to receive CORI information, Once you did receive that information, you were obligated to keep it confidential. Instead, you disseminated that confidential information to somebody who was not authorized to receive it, and you did so to further a personal purpose. The Commission took enforcement action in that case. This requirement survives your public employment. In other words, even after you were to leave state service, what you learned that was confidential, you are required by law to keep it confidential. This is a provision that would keep private entities from hiring away key public employees so that they can learn all of the secrets to assist them in gaining business with these public agencies. Now, the Ethics Commission is a law enforcement agency, as I indicated. The Ethics Commission has a 6-year statute of limitations within which it can take steps to enforce the statute, whether you are a current public employee or a former public employee. If you disclose confidential information that you are not allowed to disclose, it could be actionable. Improper use of public position can also result from political activity, campaign or political activity. The Conflict of Interest Law says public employees, you cannot use your public position to secure unwarranted benefits for yourself or others. That would involve the use of public resources for a non-public purpose. That could occur if a public employee engages in campaign or political activity on public time, in public buildings, using public equipment and supplies. To do so would constitute an improper use of one's public position if it was an abusive private use of a public resource. Now, this is where the Conflict of Interest Law and state campaign finance law sort of coexist, because both laws basically say the same thing for different purposes. That we cannot be involved in campaign or political activities on public time in public buildings using public equipment and supplies. This would involve soliciting campaign support from your colleagues, subordinates, constituents, the people you deal with as lottery employees, for example. You cannot use your lottery position in your dealings with the people who need services from the lottery and coerce or leverage campaign support. We have an advisory on our website, Advisory 11.1. In other words, the conflict law doesn't restrict us from working on campaigns or supporting campaigns or being involved in political activity. There just can't be any overlap between that private activity and our public responsibilities. You keep it separate. So that we have an advisory on our website which explains that. What constitutes an improper use of one's public position in connection with campaign or political activities. It gets fairly nuanced because the advisory, while it provides examples about what is allowed, what is not allowed, it also distinguishes between election-related political activity, non-election-related political activity, where decisions are made by public bodies and those decisions may be controversial and so resources marshal on opposing viewpoints. And what can public employees do in connection with using public resources? The law recognizes that there are certain things that affect public agencies, public departments. And the policymakers within those departments have a certain latitude without violating this restriction to inform the public discussion. Like on a ballot question to legalize marijuana. If a police department, if the chief makes a public statement concerning the effect of that question on the ability to deliver police resources, that may be allowed without violating, even though it's a ballot question and it would be political activity. It is allowed for the policymakers to inform the public discussion, but cannot otherwise engage in advocacy over that kind of an issue. So that's an advisory that we have. We have another advisory concerning making and receiving recommendations for employment. How does that involve the conflict law? How can that constitute an improper use of one's public position? Well, if you're making a job recommendation, say a friend asks you to write a letter of recommendation for them because they're looking for a job. Can you do it? Yes. How does the conflict law apply? Well, if there's an overlap between this private activity and your public job, that's problematic. You're not allowed to use agency letterhead or your title in connection with writing a letter of recommendation for a friend. That's not authorized. Are there situations where writing a letter of recommendation could be authorized? Yes. Say you supervise a summer intern, for example, and they've completed their internship, they now want you to write a letter of recommendation for them. As long as you have a basis, an official basis for evaluating the intern, and the agency authorizes you to write the letter, you can then use letterhead and your title. Your title is a public resource as an appointed employee. If you were to use your official title in a signature block on a letter of recommendation, even if it wasn't on agency letterhead, that would convey some sort of official endorsement of the letter that's not allowed under the conflict law. That's not the public's business in connection with writing a private letter of recommendation. You can write those letters on your own time using your own resources, not using your public position. Now, can you tell somebody what you do in connection with a letter of recommendation? Yes. In the body of the letter, you can identify where you work. That's part of who you are. You're allowed to do that. You just can't sign it officially as a public employee. Now, what happens if you're a public employee and you receive job recommendations? How does that implicate the conflict law? How is that an improper use of public position? Well, say, for example, you're involved in HR and you get a letter of recommendation on legislative letterhead. You have a legislator who's writing a recommendation for someone. How does the conflict law implicate it? Well, it's in connection with when and how you can consider that letter. You can't make a hiring decision solely based on a letter of recommendation from someone that might hold sway over your budget or over your agency. In other words, while we can accept, receive, and review letters of recommendation, the person for whom the recommendation is being written has to otherwise satisfy all of the other requirements for the job. That means they have to have applied for the job. They have to have gone through the screening process, possibly the interview process, and you're at that point where you're now going to consider candidates who have all met the requirements. You may then consider the letters of recommendation in light of that, but you cannot step outside of the normal hiring process and make a decision solely on the basis of a letter of recommendation. And we tell people who do write letters of recommendation, like legislators, you need to have a basis for the recommendation. So if you have a constituent that says, can you write me a letter of recommendation, you should at least take the steps to verify who they are and the job they're applying for, and to just sort of evaluate, do they qualify for the position? So that there's some legitimate basis for the recommendation. So this advisory has all sorts of useful information about what is allowed, what is not allowed, and the various considerations that go to writing letters of recommendation, reviewing or receiving letters of recommendation. Also, under the whole category of improper use of public position, what about public employees who engage in private commercial relationships with the same people that they deal with as public employees? Subordinates, colleagues, the public, your constituents, for example. Well, what's the conflict of interest implications there? Well, any public-private overlap. We cannot use our public positions to leverage or coerce private commercial relationships. So, for example, if you have a subordinate who paints houses and you need to have your house painted, can you engage their services? Yes. Well, what's the conflict law implication? You can't do it on the job, and you cannot leverage your public position to gain that. So the way it works is if you're dealing with a subordinate, they have to publicly advertise their services. And then off the job, you can then contact them. And then you cannot solicit or receive any inducements, discounts, for example. And they cannot provide any inducements or discounts. It has to be an arm's length transaction. It has to be totally voluntary. And because you're the supervisor who's going to continue to have dealings with the subordinate, once you engage those services, you then have to file a disclosure with your appointing authority, because that situation creates an appearance problem. People will wonder whether your dealings with the subordinate are going to be in the public interest the way they always should be, or because of this private commercial relationship, they're going to get treated differently. Either more beneficially because they did what you wanted them to, or less beneficially because there was some adversarial interactions in connection with that overture. So the conflict of interest, whether it's a subordinate, whether it's a colleague, whether it's someone from the public that you deal with, if you enter into private commercial dealings with any of those folks, it has to be above board, arm's length, no use of public resources, no leveraging or coercion, and you will have to disclose because an appearance problem is created under those circumstances. So the advisory explains all of that. And then if you need to review the advisory or if you have any questions, you call our office. Talk to one of our attorneys and they'll be happy to help you navigate through those waters. And then also seeking new employment. What happens if you want to leave the agency and you're seeking new employment? How does the conflict law apply to that? Well, if you are seeking new employment from the same folks that you dealt with as a public employee, the conflict law applies. As I mentioned when discussing the nepotism section, we cannot participate in matters as a public employee if it affects the financial interests of anyone with whom we're negotiating for employment. So we had, with the gubernatorial election, we had a wholesale change in administration. And so we were dealing with a whole host of questions from the people from the former administration. What are the restrictions the conflict law imposes on their ability to seek new employment? Because in a short period of time, they were going to have to find new employment. And what happens if it was from the same folks that they dealt with while they were public employees? And so the commission published the advisory on how the conflict law applies. How can I contact folks? Can I mention specific jobs and so forth? Are there issues that come into play if I am looking for employment from the same folks that I also deal with as a public employee? And the answer is yes, yes, yes. So the advisory contains useful information to help guide public employees. So let's take that and bring it full circle. Say you're dealing with a vendor and you're making important decisions as a public employee about, is the vendor performing under the contract? Should they be getting paid? You're making important observations and recommendations and performing important governmental work. And one day, when you're having your normal meeting with a vendor, they step outside of your formal relationship and say, hey, we've got this vacancy in our organization. We think you'd be a great fit. Do you want to come and talk to us about possibly coming to work for us? If you say yes and you then begin negotiating for employment with the vendor, the nepotism section of the conflict law applies. You can then not have further dealings with the vendor. You must then file a written disclosure with the boss and the Ethics Commission concerning those circumstances. What happens if you say no to that kind of an overture? You're happy where you're at, not interested in talking to them about going to work for them. Well, whether you like it or not, whether you need it or not, they just made it personal. They stepped outside your normal relationship and they made it personal by saying, hey, do you want to come and talk to us about coming to work for us? That creates an appearance problem. People will wonder, is that vendor now going to get preferential treatment because they made that overture to you? Did you say no today, but you wanted to leave the door open to explore the conversation further 6 months to a year down the road? So even if you say no to the overture, before you next deal with the vendor, you've got to tell the boss. You've got to file the written disclosure with the boss. The boss manages the conflicts. The boss can't be the boss if the boss doesn't know what's going on. So the conflict law says financial interest conflicts, step back. You might have to file a disclosure. Non-financial interest conflicts that create an appearance problem, you have to file a disclosure before you do your job. You've got to let the boss be the boss in those circumstances. Okay, now we're going to talk about a section called divided loyalties. I also refer to it as the duty of loyalty section of the conflict law. Now this applies to us off the job. I've talked about how the conflict law applies to us on the job. Gift restriction rules, nepotism, code of conduct. There are two sections that apply to us off the job. One of them called the divided loyalty section, also called the duty of loyalty section. This provision of the conflict law says this: you as a state employee, you may not act as an agent or attorney for or receive compensation from anyone other than the state in connection with any matter in which the state is a party or has a direct and substantial interest. What does that mean? Well, basically this: by virtue of you being a state employee, You have a duty of loyalty that's imposed on you by the law. You cannot compromise that duty of loyalty by representing a third-party interest in a matter that also involves the state. You can't act as an agent or attorney for or receive compensation from. That means you can't even be paid privately to work on a matter that also involves the state, even if you're not representing that entity's interest before the state. Duty of loyalty requirements. Now, for full-time state employees, that's the restriction under the law. But there's a provision in the law that governs state employees that we call special state employees. Like the governor appoints hundreds of people to advisory boards, and those positions are unpaid. And so how can the governor get people to volunteer or agree to serve on these boards if their ability to conduct private business matters before the state are affected? So the conflict law seeks to peacefully coexist with the conflict law requirements and reality. And it says, look, as to certain positions that are unpaid, or to the extent they're paid is for less than 800 hours in a year, or by the nature of the service provided to the state it allows for private employment during normal business hours, those positions can be classified as special state employee positions. And people that occupy those positions, while they're subject to this restriction, it's only in terms of those matters before the board or agency that they serve, but they're otherwise allowed to represent third-party interests or work on matters that involve the state, as long as it's not the department, the board, or the agency that they serve. And this restriction also prohibits private entities from paying state employees to work on matters where the conflict of interest law restricts the state employee. Let me give you an example. So we had a case, it's a municipal example, but the law is the same for whether you're a municipal employee or a state employee. A case involving a conservation commission member. Now, the conservation commissioners in our municipalities, they enforce the provisions of the Wetlands Protection Act. And so this developer had an application before the Conservation Commission. The Conservation Commission issued its order of conditions allowing the developer to do work within the wetlands boundary. The developer got the permit and then hired a member of the Conservation Commission to do the excavation of that property. So the Ethics Commission took enforcement action against the Conservation Commission member from receiving compensation from someone other than the municipality in connection with a matter in which the municipality was a party or had a direct and substantial interest. It also took action against the developer for paying that municipal employee to work on a matter that also involved the municipality. Both parties paid penalties for violating the conflict of interest law. There are some exceptions to the rule, this duty of loyalty requirement. State tax returns. What happens if you're a state employee at the lottery and you also have a tax prep business on the side, or you're working for H&R Block or Liberty during tax season? If you were to prepare a state tax return for someone, you would be acting as the agent for the taxpayer. You would be acting as an agent for someone other than the state in connection with a matter in which the state is a party or has a direct and substantial interest. But there's a carve-out in the conflict law that says state employees can prepare state tax returns for others without violating the conflict law as long as they're not employed by the DOR. DOR employees may not prepare state tax returns for others. Also, there's a provision that says you can be a state employee and also hold municipal office, paid municipal office. You can be elected or appointed. You can do both, as long as there's no overlap going both ways. Because if you hold a municipal position as well, you're a public employee having to observe all the conflict law restrictions in that regard as well. So the restriction for state employees who also hold a municipal position is when you're acting in your municipal capacity, you have to stay out of matters within the purview of the state. But then on the municipal side of things, it also works. So the bottom line restrictions are, if you are a state employee and also hold municipal office, stay out of matters that might involve the other entity. As a municipal employee, stay out of matters within the purview of your state employer. As a state employee, stay out of matters within the purview of the municipality. Because under the duty of loyalty restriction, you cannot represent the municipality before the state. You cannot represent the state in matters before the municipality. Also, personnel or disciplinary issues are exempted. You can assist someone in connection with a personnel or disciplinary issue as long as you're not paid for that representation. And then you can also represent members of your family, or if you serve in some legal context as an administrator or guardian or trustee, you can represent their interest before state agencies, but your state employer, your state agency appointing authority has to approve of you doing so. The second provision under the Conflict of Interest Law deals with contracts. The Conflict of Interest Law says, state employee, you may not have a financial interest in a state contract. And what that means is, as a state employee, you have a financial interest in your primary employment contract with the state. You may not have a financial interest in another state contract, which could come in the form of an additional paid state position or a vendor contract. Now, there are numerous exemptions in the law. The premise under the law is state employees or public employees, you may not use your official positions to gain an inside track on additional state compensation. In other words, to the extent you as a state employee have control over jobs or contracts, you can't hoard those to benefit yourselves or your friends or your family members. Those are to be made available on an open, equal, and fair basis. No preferential treatment, no leveraging positions to allow us to engage in any sort of self-serving conduct. Now, that is the restriction. We get a lot of questions about this in our legal division. Can I have this second state position even if it's paid? Can I work on a vendor contract? The answer is always no, unless you qualify under one of the exemptions. Whether you qualify depends on a detailed analysis of all of the relevant facts, and there are numerous exemptions and regulations that allow public employees to hold additional public jobs. Basically, as long as there's no overlap in the responsibilities of the two jobs, but there are other provisions that may apply as well. There are a couple of carve-outs, exceptions to the rule. Can I be a state employee by day and also teach a class at UMass? Can I serve as adjunct faculty at any of our state colleges? And the answer is yes, because although the conflict law restriction is in place, there's a carve-out that says state employees can perform teaching or teaching-related duties at any of our state higher education institutions, as long as in their state capacity, their primary employee capacity, they don't have any role for the financial management of the institution or the program under which they're teaching. There's no provision that allows state employees to otherwise work at the educational institutions. It only applies to teaching or teaching-related positions. Also, what happens if you work at the lottery and you're also a foster parent? And you're being paid by DCF to provide foster care services. You would be a state employee who has a financial interest in another state contract. It violates the conflict law, but for the exception that says state employees can receive payments from the Department of Children and Families as long as they've been properly designated by that department to perform the services that they're performing. And we also have a regulation that allows state employees to perform services and work for other state agencies, either for the agencies or for the vendors that deal with those agencies within the Health and Human Services umbrella. A recognition that our Health and Human Services agencies and the people that they serve and the vendors that work with them, there is a dire need for services. The Commonwealth is the largest employer in the Commonwealth. And if we were to remove that entire class of people from working for those agencies within our Health and Human Services field, those agencies couldn't get the job done. We would be removing the largest employee class if we said, state employee, you cannot have a financial interest in another state contract. There's a regulation that covers our ability to work part-time within the Health and Human Services field, either for the agencies or for vendors that provide services to the agencies, or we can work in institutions operated 24/7 by or on behalf of the Commonwealth under a regulation, recognizing that there's a dire need for services and we need all available people. And there's also a provision now that allows state employees to be state employees even if they had business interests with the state. Before it was, if you have a contract with the state, you couldn't be appointed to a state position because then you'd be a state employee with a prohibited financial interest in a state contract. But there's a regulation that says even if you have an existing contract with the state, you can be appointed to a state employee position without violating the conflict law as long as there's no overlap between the contract and the state position. Okay, finally, the last section of the law applies to us when we leave. Revolving door restrictions. What's the revolving door? Well, those are situations where public employees leave their public positions today. They go through the revolving door tomorrow, and now they're representing a client or a new employer before the agency they just left. Can they do it? Well, the answer to that exciting question is it depends on the circumstances. Not all circumstances are prohibited, some are. The conflict of interest law looks at what you do as a public employee two ways. What are the matters that you handled? And then what are the matters that you didn't handle, but they were nonetheless under your official responsibility as a state employee? To clarify that, what if you're a department head for a state agency? Everything that comes into your department is a matter under your official responsibility. But you don't necessarily deal with every issue that comes in. You have staff to deal with stuff, you deal with stuff. You can distinguish between matters that you handled versus matters that you did not handle, but they were nonetheless under your official responsibility. You then leave the agency. You now want to represent a third-party interest before the agency, a new employer or a client or some other third-party interest. The conflict law says once you become a former state employee, you may not represent any third-party interest before your former agency if it's in connection with a matter that you worked on as a state employee. Permanent restriction attaches. If you touched it on the state side, permanent restriction. And then, as to matters that you did not handle but they were nonetheless under your official responsibility, the law imposes a 1-year cooling off period. You leave the state agency, wait 1 year, you can then represent the new employer, the client, or the third-party interest. Why? Well, when you leave the agency, you still know people. The 1-year cooling off restriction allows your relationships to sort of dissipate a little bit. You can't leverage your relationships, your connections, your contacts, your network, all of that stuff. You have to wait 1 year before you can then represent the interests of some third-party entity as to matters that while you did not handle them, they were nonetheless under your official responsibility. If neither condition applies, there is no restriction. In other words, you can leave the agency today, come back and represent a third-party interest before the agency tomorrow, as long as the reason for that representation is not in connection with a matter that you handled or a matter that was under your official responsibility. There's also a restriction on partners. If you were to leave the agency and join a firm and you became a partner in a firm, say you're an attorney or an engineer or an architect or you're in real estate development and there's a firm, however it's constructed, and you're a partner, and you have a permanent restriction imposed on you by the conflict law, your partners have a 1-year restriction imposed on them so that they cannot leverage your relationships that you have at the agency. If you have a 1-year restriction imposed on you, however, there is no restriction on the partners. They can immediately represent the client. And then all state employees have a restriction on lobbying. We cannot leave our public agency and then lobby that agency for 1 year after you leave public employment. And that applies to everyone. And now we come to the most important slide, the last one. When in doubt, don't do it. The mission here today was just to educate you on the red flags. When should they go up? Some of the stuff is intuitive, but I hope you can appreciate some of the stuff is anything but intuitive. And our legal division wrestles with these kinds of questions every day. So the job was not to make you an expert on the conflict law so that you would make your own decisions on their compliance requirements, but to leave you sufficiently confused, as I often am, about the compliance rules so that when the red flag goes up, you contact our office and find out what the compliance rules are. Are there any questions? Okay, thank you for your kind attention. Enjoy the rest of your day.